Good afternoon. It's Thursday, September 19th, 2025, and we're here at the Sacramento County Public Law Library 2025. Friday, that's right. It's not Thursday, it's Friday, September 19th, 2025, and we're here at the Sacramento County Public Law Library with Senior Attorney Audrey Thornton, virtual in San Diego, and I am here, Attorney Amina Merritt, at the Sacramento County Public Law Library. This presentation is part of the Ask a Lawyer series presented by HERA and Sacramento County Public Law Library. The Ask a Lawyer series runs about 6 months, and we have one more coming up next month. So first, I want to give a disclaimer to note that this presentation is for informational purposes only. Next screen, please. Next slide, please. This presentation is for informational purposes only. It does not create an attorney-client relationship between the participants and either the Sacramento County Public Law Library or Housing and Economic Rights Advocates HERA. We're going to jump right into our topic today, which is called Survivors' Rights in Housing for Homeowners and Tenants. And we will hopefully have some time for questions and answers at the end. So if you could type your questions into the chat box, we'll try to do that if time permits. So today's topic, we're going to start with a description of the statute. The federal statute that protects survivors. The Violence Against Women Act, a lot of people have heard of it, VAWA. It's found at 8 U.S. Code Section 1367, and it states that it is illegal for a covered housing provider to deny, terminate, or penalize survivors. The Violence Against Women Act is intended to encourage survivors to report and to seek help for the abuse against them without being afraid of losing their housing. An important point is that VAWA does not just apply to women. The Violence Against Women Act applies to all survivors, regardless of sex, gender, identity, or sexual orientation, and it also applies to all of the protected categories under the U.S. Constitution. The Violence Against Women Act imposes special duties on federal housing providers, including PHAs, management, landlords, housing organizations, and anyone else receiving a federal subsidy, tax credit, or benefit. And so before I start talking about the federal housing programs, Senior Attorney Audrey Thornton is going to talk about the rights that homeowners have under the Violence Against Women Act and some other laws that apply in the state of California. So I'll turn it over to Audrey.
Thank you, Amina. Next slide, please. So we're going to talk about your rights as a survivor, starting with how to get an abuser out of the home. So the first step in doing this is to apply for a domestic violence restraining order against the abuser. Part of that order is court can grant a move-out order, or it's called a kick-out order, as part of the restraining order. The court can also make other orders to protect you, such as paying the mortgage and other debts. The move-out order requires an abuser to move out of the shared home. You may ask also, can I get a move-out order if I'm a survivor and I've already left and you want to move back in? Yes, you can. If you've moved out of the shared home to escape the abuse before seeking a restraining order, you can still ask for a move-out order in order to move back in safely. Next slide. Can you get a move-out order if you're not an owner of the home? Yes. There are several things you have to show the court in order to get this move-out order, but you can. The first is that you have to show the court you have a right under color of law to use the home. The second is that the abuser has assaulted or threatened to assault you or your child or a dependent adult living in the home. And the third thing is that you or your child or the dependent adult will be physically or emotionally harmed if the abuser continues to live in the home. Even survivors who are not a named party to the lease or do not pay the rent or are not listed on the deed have the right to request a kick-out order. Next slide. In order to show that you have the right under color of law to possession of your home, you want to show the court. There are several factors you can show the court. If you're not listed on the property deed, you could show the court that you pay a portion of the mortgage, or you contribute to the payment of property taxes. You contribute to the household in other ways, such as by cleaning or buying food for the household. You want to give the court any proof of your right to live in the property, and then you attach this proof to the restraining order request, and you explain your housing situation to the judge. The type of proof that you can attach are rent receipts, or a screenshot of an online rent money transfer, a utility bill in your name, mail that's addressed to you, and the judge has the final decision on deciding whether you have a right to use the home and get a kick-out order of the abuser. Next slide. So in terms of the mortgage, there are different situations that a survivor may find themselves in. The abuser and the survivor could be co-owners. The survivor could not be an owner, or sometimes the survivor is the sole owner. Next slide. So the question can arise, what if you get a move-out order and you can't afford the mortgage payments? In this case, the survivor can ask the court to order the abuser to pay the rent or the mortgage or other liens on the house as part of the restraining order request. You want to attach an explanation to the restraining order request of why it is urgent that the abuser pay the mortgage. For example, that the abuser is the only source of income in the household and you would lose the home if it's not paid. You can also get an order like this in a divorce proceeding after a noticed motion, in which asking the court to order the abuser to pay the rent or the mortgage or other liens. Next slide. So you can try also to get assistance in paying the mortgage. And one of the first options is getting a loan modification to reduce the monthly payment to something that you, the survivor, can afford. This is where sometimes the survivor who lives in a home where the abuser is a co-borrower may need to get this loan modification to postpone the payments. That's called a forbearance, or lower the monthly payments. And this requires an application to the mortgage lender for this. However, an issue may arise. What if the abuser won't sign the modification, or it's dangerous for the survivor to obtain the abuser's signature for a loan modification? Next slide. This has been considered by some mortgage lenders, and some lenders don't require the abuser's signature on the application for a loan modification in this type of situation. If the survivor's mortgage is insured by the FHA, the Federal Housing Administration, their policy clarifies that the lender has to consider the survivor's application for a loan modification without the co-borrower's signature, i.e. without the abuser, who happens to be a co-borrower, signature on it, and has made a policy under the FHA that a signature is not required where the co-borrower is unavailable because of divorce, legal separation, domestic violence, among other reasons. That is the FHA's policy where they insure the mortgage. Now, for other lenders, next slide. If your mortgage is backed by Fannie Mae or Freddie Mac, their policy is more unclear, unfortunately. Their mortgage standards do not mention domestic violence as grounds for waiver of a co-borrower's participation in getting the loan modification. They will consider a divorce or a court-filed separation agreement as grounds for such a waiver, to waive the signature of the co-borrower. They also allow for an evaluation based on a case-by-case basis regarding whether a co-borrower must sign a modification agreement. So even if the lender, this is the last alternative, federal or private lender, would typically require the co-borrower's signature and participation in loan modification, the survivor can explain and write a letter of explanation that the abuser's participation in this loan modification should be waived for the survivor's safety and well-being, and the lender should follow the FHA's policy. Next slide. So the loan modification application may be submitted, and do you have the right to, what do you do if you face discrimination as a survivor of domestic violence and are denied a loan modification? Well, you always have the right to an explanation of the basis of denial by the lender, and you can ask for that. You can also self-advocate, which means talking to them and asking the situation, the request to be escalated. You can also seek assistance from other consumer advocacy organizations. And we would suggest that you, if you're in that position, contact your legal aid organization for advocacy. You can also file a complaint with the Consumer Financial Protection Bureau. Next slide. There may be a situation in which a survivor does not want to take on the mortgage. And if a survivor owns the home with an abusive partner and no one's paying the mortgage, the home may be foreclosed. So the survivor can consider a personal bankruptcy to discharge the mortgage debt, or the survivor can utilize a third party, such as a realtor or an attorney, to try to convince the abuser that it's in everybody's best interest to sell the home and come to some sort of solution that way. Next slide. The reason of getting a private sale worked out, it's best when the home is worth more than the outstanding mortgage, and there'll be some equity left in it after it's sold. However, if there's no equity in the home, a short sale of the home may be the best solution. This is where you ask the mortgage servicer for permission to sell the property at fair market value and accept the sale proceeds to satisfy the mortgage in full, even if the proceeds are less than the amount owed. And another option similar to that is to ask the lender for a deed in lieu of foreclosure. That is where the client and the abuser voluntarily transfer title to title to the property to the lender in exchange for a release from liability on the mortgage debt. In all these situations, it's very important to make sure that in any arrangement that it's clear that the survivor has no further liability on the mortgage. Next slide. There are many cases which arise concerning survivors of domestic violence in which the debt on your home has been coerced by the abuser. In California, the survivor can ask the court that is issuing the restraining order or protective order to make a special finding that specific debts were incurred as a result of financial abuse. On the restraining order form, it references that, and it asks under number 22B, if you did not agree to the debt or debts listed above, you can ask the judge to decide that one or more of the debts was made without your permission and resulted from the person's abuse. This may help you defend against the debt if you're sued in another case. You can get a temporary court order that, in this way, that certain debts were a result of domestic violence and should be paid by the abuser. You can also get an order in a divorce proceeding after a noticed motion that specific debts were incurred as the result of domestic violence and without the consent of the party, meaning the survivor, and an order by the court requiring the other party, the abuser, to pay them. We can talk about this more later if you have any questions. However, one of the ways of describing this kind of debt is a coerced debt. And to advocate or prove that this is a coerced debt, the survivor can file an identity theft report. However, the first step in proving it is obtaining a restraining order or filing a police report. Okay, next slide. Now, if you are living in a community with a homeowners association, survivors do have protections as survivors of domestic violence with regards to their HOA. Under California's Fair Employment and Housing Act, FEHA, it's illegal to discriminate against individuals on the basis of several factors, which include discrimination against survivors of domestic violence. The HOA has a third-party obligation to get involved if a member of one of these protected classes is being harassed or discriminated by another homeowner. Okay, next slide. Situations may arise in which there's code enforcement by the HOA, and often it occurs when a survivor of domestic violence has to call law enforcement to aid them. There are protections available for survivors in these situations. It has been shown that crime-free clauses in an HOA agreement may discriminate against survivors if they're enforced to prevent that survivor from calling law enforcement. Next slide. Under California law, survivors of abuse, crime, and individuals in emergencies cannot be evicted or penalized for calling the police or summoning emergency assistance. California law supersedes local ordinances, that would mean a town ordinance or a city ordinance, that might penalize a survivor of domestic violence due to their police calls or emergency assistance summoned to a property. And this is a situation which may happen in a closed gated community with an HOA, where a survivor needs to call the police frequently because of the abuse that's occurring in their home. Next slide. We're now going to go to my colleague, Amina Merritt's portion of this workshop. Thanks, Amina.
Thank you, Audrey. That was all great information, a lot of stuff I didn't know about home ownership and protection under the Violence Against Women Act. And I just wanted to make sure that we point out that the Violence Against Women Act actually covers 4 types of categories of survivors, not just victims of a domestic violence, but also victims of dating violence, which some people call intimate partner violence nowadays. Also sexual assault by someone, and also stalking. Those are the four categories really that the Violence Against Women Act protects. Those are the categories survivors fit into. Next slide, please. So now I'm going to talk about the public and subsidized federal housing programs. And the reason I'm going to kind of go fast through these next slides, because the real point of these slides is to determine what kind of federal housing a person might be living in, and therefore who is required by law to notify the tenant of their rights under the Violence Against Women Act. So the first thing to notice is that the U.S. Housing Act of 1937 is what created the Housing and Community Development Act, and that is found at 42 U.S. Code sections 1427, et cetera, and also 13661 through 664. You can also reference the federal regulations at the Code of Federal Regulations, Title 24, Parts 5, 8, and 35. And these regulations all specify exactly who is supposed to give notice to tenants of their rights under VAWA. So let's quickly go through these different housing programs, talk about what they are and who is supposed to give notice to the tenant. First, most people are familiar with Section 8. It's tenant-based rental assistance. And those are housing choice vouchers where HUD makes payments to local public housing authorities for low-income tenants' rent, and where the tenant chooses where they want to live. There are also project-based vouchers that stay with the unit, not with the tenant. And under Section 8, there's also moderate rehab payments made to public housing authorities for landlords to rent to low-income tenants. All of those Section 8 programs require the public housing authority, the local public housing authority, to give notice to tenants of their rights under VAWA. It's the same with project-based housing, where a housing choice voucher might apply to a home ownership program. HUD is giving funds other than moderate rehab funds, and you shouldn't confuse this housing choice voucher, project-based housing, with project-based vouchers in tenant rental housing. Next slide, please. These are some other federal housing programs where rent by covered housing providers is also subsidized by HUD. The Veterans Association gives out vouchers they're called HUD VASH vouchers. And those are, VASH means Veterans Affairs Supplemental Housing. It combines rental assistance, case management, and clinical services for homeless vets and veterans. And those programs are administered by the Veterans Administration, and therefore the VAWA notices are required to be given by the Veterans Administration. This category of non-citizens and other immigrants is sort of a special category I've put here because normally Rule 214, most people know it as Rule 214, is actually a section of the Housing and Urban Development Act, which says that immigrants are normally excluded from the federal housing programs. However, there are many exceptions to Section 214 for eligible non-citizens. And so VAWA gives protection to survivors who are immigrants and gives them immediate access to public housing and benefits. And those notices are required to be given by the Public Housing Authority. So if someone is a survivor and they are a non-citizen, they are allowed to access the Public Housing Authority and seek protection if they also are an eligible survivor with a petition for humanitarian asylum, SIJS, Special Immigrant Juvenile Status for foster children, a U visa or a T visa for trafficking victims. The Violence Against Women Act law parallels the USCIS system for protecting victims. And in essence, it says that immigrant survivors can leave safely, get emergency help from the Public Housing Authority, and get a green card in order to be safe in the country and in their housing. Next slide, please. Some more federal housing programs include supportive housing for the elderly under Section 202 and disabled housing under Section 811. These programs are presented by nonprofit sponsors of housing, usually for the elderly and disabled tenants. And the supportive housing usually funds construction and substantial rehab of rental housing. The VAWA law requires notice of rights under VAWA to be given by the nonprofit or the housing provider. Whoever is providing that program is required to also notice tenants of their rights under VAWA. The same with under Section 211 and Section 238, the landlord is required to give notice. These federal housing programs are where landlords are given below market interest rate loans, usually below 3%, because they promise to rent to low and moderate income tenants. And these are usually small multifamily or single family homes where the rent is HUD regulated. The tenants are still entitled to VAWA and FHA notices in the lease, and the landlord is the person who's required to give those notices. Under the HOPWA and Native American housing programs, the provider must give VAWA notice. HOPWA stands for Housing Opportunities for People with AIDS. And these programs give block grants to states and local governments or nonprofits to give housing to persons and families with AIDS or HIV. And Native American housing programs are where HUD gives grants to the tribes for new acquisition, rehab, loan guarantees, or technical assistance. And with those programs, the provider of that housing is required to give the VAWA notice. Next slide, please. Now, your landlord, if you're a tenant renting, the landlord in your building may have layers of federal assistance that could make you as a survivor eligible for the VAWA protections. And so here are several of the last programs I'm going to summarize under the HUD Act. Housing Trust Fund and the Rural Development Multifamily Program. The primary purpose of the Housing Trust Fund is to increase and preserve rental housing and home ownership for extremely low and very low income and homeless families. Home Investment Partnership Program is for state and local governments to acquire, rehab, and build new housing for sale or rent for non and for-profit landlords who then give tenant-based rent assistance. And these programs also include rural development of multifamily homes. And so under those programs, the program must give notice. It's the same with McKinney-Vento. Many people have heard of McKinney-Vento because it is the law that provides homeless assistance and supportive housing and services for homeless in transition. The programs are designed, to help promote independent living. And these programs are usually administered by a continuum of care for 3 homeless assistance programs in several counties of California: Shelter Care Plus, SRO Section 8 Moderate Rehab, and Supportive Housing. Excuse me. So this resource, the National Property Database, the Preservation Database, can help to identify your property And you can go on this website to determine which federal programs or federal credits the landlord of that property, the owner of that property receives. And if there are any federal credits or federal programs that apply to that property, then the Violence Against Women Act and the Fair Housing Act do apply. Federal law applies. Next slide, please. Thank you. So again, VAWA prevents the public housing authority or the landlord from discriminating against a survivor when they're renting the property. So at the very first point of applying for public housing, there can be no discrimination against a survivor because they're seeking housing as a victim. It also allows a current tenant to move without suffering a penalty for either breaking the lease or the rental agreement. And as Audrey pointed out earlier, you cannot be discriminated against as a survivor because you call the police all the time and therefore possibly violate the nuisance clause of your lease. That is not just cause for you to be evicted because you are constantly making police reports as a survivor. Next slide, please. So in order to, and this is some practical advice, that in order to obtain protection under the Violence Against Women Act, a survivor should document the domestic violence, the stalking, the sexual assault that causes them to fit within the definitions under the Violence Against Women Act. And in 2022, the Violence Against Women Act was amended so that survivors get to choose what type of documentation they want to submit to prove their status as survivors under VAWA. They get to present, quote, any credible evidence, end quote, and the housing provider must accept the documentation that the survivor gives. It can even be the newest HUD form 5382, which is found on the HUD website, and also many public housing authorities put it on their website, so that the survivor can create their own self-certification statement that is in chronological order describing the incidents of abuse that they have suffered. And if there's conflicting evidence, a landlord might be able to require additional proof. But in essence, the Form 5382 is a self-certification of the survivor's own statement that should be accepted. And the amendments in 2022 mean that survivors do not have to contact the police or initiate legal proceedings against abusers or perpetrators. And although Audrey previously outlined all the requirements of obtaining domestic violence restraining orders or temporary restraining orders, those are no longer absolutely required for a survivor to get protection under VAWA. They can self-certify. But a police report does help. It does support proof that the survivor actually called the police and reported the incident. And the restraining orders, temporary or permanent, do provide the same type of chronological evidence. The judicial council forms that are required in the state of California somewhat mirror the HUD Form 5382 in giving a chronological statement of the survivor's experiences. And someone can also submit a statement from a qualified third party, for example, Weave, My Sister's House, any domestic violence shelter where a person has reported to a case manager or victims assistance person what has happened to them. A doctor or a mental health provider can also provide a statement confirming proving that a person is a survivor of the four types of violence that VAWA covers. Next slide, please. So the Violence Against Women Act also prohibits providers of these housing providers under HUD from discriminating against survivors by saying you have repeatedly violated your lease by creating a nuisance. I alluded to this earlier, that is not good cause for evicting a person under a nuisance clause of a lease. And you also cannot deny housing assistance, or a public housing authority cannot refuse to provide a voucher or other housing assistance merely because the victim has been involved in what they consider criminal activity, because that activity was the basis or a direct result of their status as a survivor, or adverse factors that result from the abuse. For example, windows might get broken, doors might get broken, noise ordinances may be broken. And that may cause there to seem to be a criminal violation. However, if the person is a survivor, they should be excused from those adverse factors. Next slide, please. So again, VAWA requires the tenant to have given written notice of their VAWA protections. And the housing provider is required by VAWA to keep that tenant's status as a survivor confidential. This is important because many of our clients have reported that they've heard property managers mentioning them as survivors. They've heard property managers mention that someone has moved out because they were a survivor. That is a breach of your confidentiality as a survivor, and it shouldn't be done. And it might give rise to a complaint against that property manager for doing so. VAWA also allows, similar to as Audrey described with the mortgage, allows a housing provider or a public housing authority to split the lease and evict the abuser from the public housing program. It will allow the survivor to stay in the unit, or if you don't qualify for that particular voucher or program, you get at least 90 calendar days to establish eligibility for the particular program you're living under, or for some other covered housing program, or to at least find alternative housing. The main thing is that survivors are not left to their own devices. If they are a survivor, they are entitled to have assistance from the public housing authority. And so the public housing authorities should have an emergency transfer plan on their administrative plan, which can be found on their website. And it should allow the survivor to move without providing the normally required 30 days notice of termination of the tenancy. And it should also allow the tenant to transfer their Section 8 voucher to some other housing authority if they need to move to another county or to another state, which I've been successful in getting for a survivor. Sometimes that's necessary. It's also important to point out that VAWA requires the notice to be given in the language of origin if there is a monolingual Spanish speaker or other. In California, we have 8 recognized languages. Our ballots are printed in 8 different languages. And so VAWA notices should be given in those same 8 different languages. And the administrative plans for the public housing authorities are required to have the emergency transfer plan as well as the language access plan as part of their administrative plan. And this is a topic that is constantly coming up when administrative plans are amended. locally, you can participate in that as an advocate to help make sure the emergency transfer plan complies with VAWA and gives VAWA victims access to public housing authorities, and also gives immigrant survivors the proper access they're entitled to for public housing and benefits. The next slide, please. The main goal of these provisions for the public housing providers is to create safety in the tenancy. And so if a survivor does not want to move, then they should be able to work with the housing provider or their case manager to improve their security in their current housing. And they can do that by making a written request, because VAWA does allow a landlord to make structural changes to the apartment unit in order to increase a survivor's safety in their tenancy. In fact, VAWA allows a landlord to install high-quality locks on doors or windows, or to change the locks if necessary to keep the perpetrator out. You can ask to install security cameras. A survivor can ask to increase the lighting around their doorway or to increase lighting at access points to the apartment. They can ask to trim shrubbery where a perpetrator may be hiding to attack them. And they can also ask to assist with a safety or escape plan under the HUD Form 5381 Model Emergency Transfer Plan for victims. Landlords and housing providers can actually assist with that to help a survivor make a safe escape from dangerous housing. Next slide, please. So when a victim does want to move out of the unit, the housing authority must ensure that the victim, the survivor, not the perpetrator, retains the federal housing assistance. And that's why I said earlier, the public housing authority has the right to give the voucher or the housing assistance to the survivor and to terminate the perpetrator's assistance. The family might move to protect the health and safety of the victim and may violate the lease if they reasonably believe they are imminently threatened with future violence. And they can request that the voucher be transferred in their name because of the abuse. I have a good anecdotal story about this because I had a survivor client who jumped in her car one night with her children and fled a violent apartment where her life had been threatened and the life of her children. And she got in the car and drove to another state for safety. And it was important that she have assistance from the housing authority in California to transfer her housing voucher for her and her children to another state. And HERA was successful in making that happen. It's important that the victim get immediate protection. VAWA is designed not to wait until tomorrow or next week, but to give immediate protection to a survivor. Next slide, please. So one of the other ways to protect survivors is that they can get a new confidential address when they move from the place where they suffered abuse. And everyone is required to keep that new address confidential. In fact, that is why the Secretary of State for California allows survivors to enroll in address confidentiality or a mail forwarding program. And you can obtain a P.O. box through California's Safe at Home program, Or when you're filling out documents or public forms, you could list the address of a trusted friend or family member, or you can even write confidential in the address portion of certain documents, including a restraining order application. You can ask on the restraining order documents. The judicial council forms even have a box where you can check to ask the court as part of the restraining order to prohibit the abuser from taking any steps to try to learn the survivor's new address and to prevent them from searching you out. The landlord in the federal housing program must keep that new address confidential. And so if a survivor needs a confidential address, you can access it at www.sos.ca.gov. The Safe at Home program will allow you to access that. Next slide, please. So again, the proof that's required to get legal protections as a survivor include a police report that shows abuse within the last 180 days, a domestic violence restraining order, or a protective order within the last 180 days. As I said earlier, a letter from a counselor, a doctor, a shelter, or a therapist confirming that the survivor sought assistance. And also, as I stated earlier, the HUD form where you can self-certify since 2022 that you are a victim or a survivor. Next slide, please. So domestic violence is a defense in an eviction case, which is also called an unlawful detainer lawsuit. You cannot be evicted for making excessive police calls, and it is a defense if the landlord seeks to evict you for the nuisance clause under Civil Code Section 1163.3. And unless a HAP contract or other document applies, all the landlord-tenant laws must still be followed by the housing provider. A caution, if you have a restraining order as a victim or survivor, do not violate it and let the perpetrator back in the home. You may be subject to a 3-day notice to cure, and the landlord can then evict you if you violate the restraining order. And also watch out to prevent having the perpetrator be living in an apartment with you if they are not an authorized tenant, because that could get you evicted as well. Next slide, please. Just want to point out again, as Audrey did earlier, that the Fair Housing Act found at 42 U.S. Code Section 3601 also provides protections against housing discrimination based on the protected categories. And she showed that slide earlier. I have just highlighted the ones here that normally we see as survivors: race, color, religion, national origin, sex, disability, familial status, and veteran status. Next slide, please. Also, we want to point out that you have the right not to have your application denied because you're a survivor, because you have poor credit, because of your rental history being sketchy, you keep moving, you have unpaid rent in places you fled from, you have prior utility debts from places you fled from, or you made prior lease violations, all that are a direct result of domestic violence, then you are protected under the Federal Fair Housing Act. And so the next slide tells you that if you are the victim of discrimination based on your status, you feel you were denied housing, the housing provider has to tell you the reason you were denied the housing, and you have the right to understand and challenge the basis of your denial. If you're denied housing in a federal housing program, you have the right to an administrative review, potentially, depending on the housing program. There are different levels of review depending on the program that you're seeking housing assistance under. So you may be entitled entitled to challenge the denial of housing assistance if you feel it's based on the fact that it's your status as a survivor. And finally, next slide, please. People can complain of VAWA violations in public housing by filing a public housing grievance with the local public housing authority office. You might also seek informal review and hearing through the Public Housing Authority. And again, I said it depends on which housing program you're in, who was entitled to give you notice, and what remedies you're entitled to in that particular program. You may be entitled to a public hearing locally. For example, in some cities of California, there are rent stabilization boards that exist by local ordinance, and they are charged with reviewing violations of local ordinance and law. Or you might want to go to your board of supervisors or your city council and complain about violations of the Violence Against Women Act by housing providers in your city or county. The Office of Fair Housing and Equal Opportunity, FHEO, is the regional office in California. Northern California, we have an FHEO in San Francisco that is the regional office for filing complaints related to violations of VAWA. And then finally, of course, people have recourse as private plaintiffs in U.S. District Court to enforce federal law. So with that summary of the federal housing programs, we're going to open it up to the audience. If you have any questions regarding either home ownership protections for survivors or protections for survivors as renters, as tenants. So if there are any questions, we'll field them now. Michael, do we have any questions?
Yeah, no questions for now.
Great. Okay. Well, I guess we will wrap it up a few minutes early. I actually had a question for you, Audrey, and I think this discussion might help the general public because I think people are wondering this as well. You mentioned that one recourse for people as homeowners is to complain to the CFPB. And
Right.
I wondered if you could talk to me a minute about whether there is a complaint viable now, given what has happened at the Consumer Financial Protection Bureau, CFPB.
Yeah, prior to this administration shutting down the CFPB, basically, it was a very good, it was a very good place to law, agency to lodge a complaint about a lender not following the law, discriminating against you. However, at this point, it's important that the complaints are going to be received and they'll be logged in. If you have a complaint against a lender discriminating against you or not allowing you to get a loan modification, however, they may not be acted on. However, we suggest that complaints still get filed and there will be a record of them. So if the agency is, staffed at some point and gets up and running again, it will have all those complaints against, that lender.
That's important current information. It's the same for housing and urban development, which has been gutted virtually by this administration, and the staffing at the San Francisco regional office is really low. However, the advice that we are receiving as housing advocates from all over the state and country is to keep filing those HUD complaints, keep filing our VAWA complaints, and we hope that the staffing will increase so that they will be addressed. Just survivors need to get in line and still file their online complaints that you have access to through the Housing and Urban Development Department. So that is our advice. And before we wrap up, Audrey, I just wanted to point out that HERA is seeing survivors on on your team, the homeowner and foreclosure prevention team. Also, we're seeing survivors on the tenant and homeless prevention team. And we're also encountering survivors at HERA runs a debt collection clinic in Modesto and in Sacramento. And I am constantly getting debt collection clients who have coerced debt that I discover through taking the intake at the Hall of Justice here in Sacramento. So it can survivors can come to our attention through several different mechanisms, not that they're coming to us as survivors, but that, you know, we sometimes discover that fact when we do our intake for other issues.
Yes, sure. Yes, definitely. That's true.
And they're kind of global issues, just for the benefit of any survivor who is listening. You know, the problems that occur for survivors do include debt, housing, and tenancy problems because of the abuse that survivors have experienced. So it could be a constellation of problems that is not just for one of our teams, but it crosses over on our teams.
Right.
Yes. Well, thank you. And thank you all out there in virtual land for your attention. Hopefully this has been helpful, and we look forward to seeing some of you next month at our next presentation for the Ask a Lawyer series. Thank you, Michael, for all your assistance.